Good afternoon, everyone, and welcome to another episode of Speaking Legally, where the legal meets the cultural, brought to you by Destiny Designs University and our co-host, Royce Russell Esquire, Edward Pichardo Esquire. We greet you today. We know we're post Valentine's Day, but I believe every day is a day to share and spread love. So we hope that you're staying well, you're staying safe. Thank you for tuning in.
Spread love.
Oh, we go live today.
All right,
where the legal meets the cultural, and clearly some people think that they're musicians as well. Hey, Rich Russell, thank you so much for joining the show, and thank you for the heart. So we're sending love out to all of you. Thank you for your participation and engagement in the topics that affect our community. You have two legal experts here each and every week that touch on information even before it hits mainstream news. Let me find out somebody's watching us and taking our stories, but that's a whole nother story. We're waiting for Byron Allen to just give us a call. You were just singing that, Richard. Clearly, that's your brother. But welcome to the show today. We have a packed show with more information. We talked about some of the implications of COVID-19 and how that can affect employment for people who are not comfortable going back into the office. And if you don't have the wherewithal to be able to stay working safely at home, you might not have a choice. And we went through a lot of the legal information that surrounds how those decisions are made, what's in your employee manual. Some folks have never looked at their employee manual. So it would be about time for you to understand that. And if you get sick, what happens to your job and the protection of your job. Hi, Avis. Thank you for joining the show today.
Ed, did you hear what Dr. Grant said? She said, "It be about time." You know, put an underline and put a quote on that. It be about time you start to read that right there. That sounds like something like go get the switch and come on back. You know, it be about time. You know what I mean? Like, I'm just saying, you know, this is where we go.
Honey, you need to protect yourself in these COVID streets. A lot is going on, and today we're going to touch on something else that's affecting our community, and our legal experts will once again give us their insight on it. But before we get into that, we lost another legend, and we want to pay tribute to a huge giant in our Latino community. And I want Mr. Pichardo to give that tribute as we want to honor him and all that he brought to not only the music industry, but to merging the cultures in Latin America. So over to you, Ed.
Yes, we suffered a huge loss yesterday by way of Johnny Pacheco. I'm not sure how much of the members of our audience know of Johnny Pacheco, but I would imagine they recognize a more familiar name, Celia Cruz, or even Ruben Blades, who's appeared in several Spike Lee films, or Willie Colon, who has run for, I believe, mayor or controller. You know, these are people that are more familiar. Johnny Pacheco was actually the guy really behind the scenes. He was the co-founder of a record company called Fania Records. He was actually Dominican, and you know, most people think he's Puerto Rican because he was surrounded by so many Puerto Rican artists. Ruben Blades, the exception, being Panamanian, I believe. But you know, he was responsible for a huge body of work. In fact, you know, after my father passed away in April, I noticed, so I knew all along that he had this huge wax record collection. And one of the first things I grabbed were the records that Johnny Pacheco and Celia Cruz did together. And I just want to kind of show the audience, like, for instance, this one right here has a young Celia Cruz with a young Johnny Pacheco. You see the afro. This is actually from 1974, actually. And I have those. I got another one, a solo record that Johnny Pacheco did. He was a flutist. He was actually Juilliard trained. He came to America at the age of 11, and he created a legendary a record company that yielded so many artists, so many albums, so many songs, so much music. And he bridged together, Dominican, Cuban, and Puerto Rican music at the time into what was eventually referred to as salsa, which is really looked upon as a New York-based, New Yorican commodity cultural creation. So I just want to send shout outs to Pacheco, el maestro de los maestros, que en paz descanse, hermano. May you rest in peace. May you rest in power. He was a legend. I welcome you to listen to the music. For some of us, we may think, I can't, I'm not going to be able to understand the words, but this is rich in so much African-based percussion. If you listen to this music, trust me, you're going to recognize, and you're going to say, yo, that's from the motherland, baby.
Hey,
so
Ed, let me tell you something. If the litmus test was understanding what was being said in music, then you could scratch all the rap off the table, brother. You see what I'm saying? So don't set the standard as to recognizing what is being said, and let's set the standard where it's supposed to be, and that is the soul in your feet, and your feet hitting the floor, and you doing what you're doing, whether it's salsa or whether it's your make-believe salsa,
make believe.
The make believe salsa is when people really don't know how to salsa, so they try to do the hustle and try to make it look like the salsa. You know what I'm saying, Ed? We know what that look like.
No. And listen, it's amazing that you mentioned that because some of us that are bilingual, we recognize that music kind of as an early form of Spanish hip hop, even before reggaeton, because the music from back then in terms of Fania was the music of the streets and what was going on in these Latin communities in East Spanish Harlem and say Williamsburg, Bushwick, they used to talk about the streets. So when you talk about hip hop reporting what's happening on the streets, this music actually did that. It used to talk about the hustlers. It used to talk about the clubs. It used to, this music is rich culturally. So, I just wanted to drop that little drool there for the audience and welcome all of you to explore.
Well, I'm glad you were able to do that, and maybe we should have saved that for last so we can have a favorable moment as we end this show, because Dr. Grant is on some Earth, Wind, and Fire. She on some Earth, Wind, and Fire. And so,
yes,
you brought the earth and the wind, and now she's going to bring the fire. So now I'm going to be the host of the show, and I'm going to kind of direct it from this way. Dr. Grant, there's some words you want to share upon us about the legal system and media and what's happening in today's world, please. The floor is yours. Go ahead.
I absolutely do. Thank you, Mr. Russell, because I'm very disturbed at a particular article that I read in the news that was brought to my attention about a recent situation that we've discussed here on Speaking Legally, where a woman falsely accused a Black man in Central Park of attacking her. I think we all remember that story, Miss Amy Cooper. So apparently she has now been, the charges have been dismissed. She was required to do some, not community service, therapy sessions. And the therapist reported that she did a great job and seemed remorseful, etc. And as the story broke, you can see what's said here. Amy's story will be released in coming days. Lawyers suggest Amy Cooper may bring lawsuits after criminal charges dismissed. Say what now? And when you go down and read more of the article, the attorney is insinuating that she has some sort of case or recourse because now that her charges have been dismissed, she's exonerated from any wrongdoing. Caller, what say you? Because I'm hot under the collar about this. Not the fact that she did what she needed to do, because I know that happens in the legal system. But where is this attorney talking about she might file charges. Charges about what?
Well,
sometimes what you have is you have what we call talking heads, right? And that is people that give commentary just for the sake of giving commentary. And I know you're hot under the collar, given that you don't have any collar, so you must have burned it off just being so damn hot, showing that neck. But here we go. What we have is the media doing what the media does. And, as much as I hate the saying, you have a lawyer talking out of both sides of his mouth. Now, we all know that we could look at the Son of Sam laws and we could dig deep in that. Anytime you commit a crime, the odds of you being able to benefit financially are slim to none. So, I mean, we can explore that, its applicability in this particular case. However, she needs to just shut up, back up, and get in where she fit in. And I sense your anger and frustration that the media even titles this as such, as if she got away with something, as if, the accusations that were brought against her was false and she's a victim. And I can completely understand that. But she had to go see her therapist, which I'm sure she's continuing. And, if you weren't guilty and if all this was false, then you wouldn't be on that couch putting in your hours so you can get the case dismissed.
Yeah, I mean, absolutely. I think this is one of those wait and sees that we're not going to see. I mean, I can't really think of a situation where she's going to have some sort of legal recourse against anyone based on this incident. She needs to basically quietly go away. What she took advantage of was an alternative to incarceration program or disposition that allowed her to walk away from this case without actually having to do any sort of jail time or otherwise be convicted of a criminal offense, it appears. So she needs to, thank her lucky stars for that. I would imagine that she's still suffering the reverberations and consequences of this conduct, because it was all over the national and even international media. I believe she lost her employment based on it. I do share Dr. Grant's frustration here, but at the same time, we're finally seeing that America is starting to deal with this issue of discrimination. And starting to confront it head on in a number of cases, because I'm waiting to find out what's going to happen with this other woman who assaulted the young man in the hotel over that phone, and what's happening with that young lady. And also DA's office, Manhattan.
That race is wide open. And what's interesting about it, now that you bring it up, is where are the candidates? Have they said anything publicly? Have they denounced, this disposition? What are their positions in reference to this? Because that is a true litmus test as to whether or not that is the right person for the job. And not only that, when you take what the lawyer said and you drill down on it, you realize that it is nothing but hot smoke and blowing smoke up your nose, in that you can't sue the DA's office because they're immune. They have immunity. So where are you going with that? So you got to take them out of the box. You can't sue the police because there's not a false arrest, because you actually have a complaining witness who said that this happened. So you don't have the police on a false arrest. And you can't sue the victim for slander because it is on video, it is on tape, which supports the misdemeanor accusation or accusatory instrument that was drafted, which led to her arrest. So I don't see any W's in here. I see a lot of no gots,
Yeah, I think sometimes, when people got that mic in front of them and they're confronted by the media, they feel the need to just say something instead of just maybe saying no comment.
Well, here it is. Here it is. I agree with what you say, but I'll just underline the word when they're confronted by the media. The media don't really confront anybody. You're not forced to say anything. You can keep on walking and do this talking. But we're in a capitalistic world, and opportunities are what they are. And
well, I just meant, like, sometimes you get the client who'll be like, you didn't even say anything. You didn't stand up.
Yeah, look. I
You're like,
understand that. I understand that to be true, but he probably got paid his fee. So I didn't say
yeah, I would imagine so, right?
What you talking about?
Maybe he did. Maybe he has to send that invoice. He's trying to make sure that he gets that check. Who knows? Anyway.
I will move on because we have more to discuss. But I'm like, come on, son face. Like, I'm bringing that back. Like,
come on, son.
Yeah. Like, what's good? Like, okay, let me calm down. I have to calm down because I get triggered by certain things, not everything. And I know what my triggers are. So I just need to work through them and just center myself with where I am. But like you said, wait and see. Hopefully there's nothing to see. But just putting that out there, to me, it just gives fuel and fire to the ignorance that already exists when it comes to racism, period. Like, it is what it is.
We've seen this on a bigger platform, right? When we talk about the insurrection, you had attorneys talking about their clients that were caught in the Capitol doing acts of violence, trespassing, and they're trying to tell you what we call straight face, right? With no chaser, what we call the red face rule, right? If your face turns red, we got a problem. That these individuals are good people. You didn't see what you saw, as they say, what's that new Fritos commercial by Shaggy? It wasn't me. I mean, that's been out for a long time.
It wasn't me.
That type of deal. So, we live to move on. We live.
Yes, indeed. And I will woosah, Rich. I will. This is a big woosah. And that whole thing, I don't know how people watched it all because my pressure would be through the roof. Because you just want to literally jump in the screen and have a personal conversation with folks. But anyway, as we move on, we talked about employment, the challenges that are happening that everyone needs to be aware of and how to protect themselves. Today, another hot button topic is housing and what to do if you can't pay your rent, you can't pay your mortgage. You're in a situation now where you might be out on the street. And we know that there were some moratoriums that were put on evictions and things of that nature. But our two expert attorneys are going to delve into that subject matter today because we need to know culturally how to protect ourselves, and especially those who have gotten to the point where you have a home. We don't want you to lose a home because being a homeowner opens up other opportunities. And those of you that are in apartments where eviction might be lurking around the corner in 2021, what can you do? What do you need to know? And I really want us to get into this and hopefully help our audience and our audience's connection. So share this broadcast with anyone that you know that COVID-19 has had a severe challenge and impact around their housing situation. So over to you, Mr. Russell.
Let me just say, first of all, there are attorneys that practice in the area of landlord and tenant. And so you should always seek their advice because that's what they specialize in. Secondly, what I would say is that just in any of our segments, and this one in particular, because we're going to be reading some rules and regulations and some guidelines, is that, anything that we say here that you gravitate to, you need to research further. It does not create an attorney-client relationship. So but we give you the information because sometimes information can be hard to find. But if you reach myself or you reach my partner, Ed Pacheco, we'll be more than happy to put you in contact with attorneys that focus directly in that area. But from an informational standpoint, to start the ball rolling, we better make sure that Danny B is on this call right here. Because remember, Danny Barber put up, what about evictions last week or the week before? So Danny B, if you out there, you better get it on or catch the recap later on with your nightcap, but make sure you catch a little bit of it. And so one of the things in doing just a little bit of research, I've realized that there is an administrative order out, and I'll read from it because I don't memorize it and didn't have a need to. I'll read some of it. What it says is that there is a stay of any pending residential eviction proceedings. Any residential eviction proceedings beginning on or before January 27, 2021, there should be a stay for 60 days. Now, I know, Ed, you're going to drill down in it, but let me just go through a couple of the do's and don'ts, and then you can go down and take it even further. There is an exception to that. The exception to that is that any action against a resident who is persistently and unreasonably engaging in behavior that infringes upon somebody else's rights that lives in the premises, what they call use and enjoyment. That means enjoying your apartment, enjoying your property, or cause safety hazards to others in the building, those matters may be heard, right? And we'll talk a little further, but there's a big distinction. There's a distinction between evictions, because lack of payment, and proceedings where you are being a nuisance or creating health issues for others. Those the court will hear. Then further, the order goes on to say all filings must include any affidavits, which are proof that filings were served upon parties. They will not accept any documents without that. There is a bar, and in this, and what we mean by bar, that means there's a stop on any issuance of enforcement of any default judgments. And so let me first define what default judgment means. Default means that you fail to appear, you fail to do something, you fail to answer, you fail to take action. That's the definition of default. Judgment is what the court actually rules. So a default judgment is a failure to do something. So therefore the court granted a judgment. And in this particular case, if I was a landlord and I filed a claim against Ed Pichardo, now we're talking about in the residential sense. We have not drilled down in the commercial sense, and we are not drilling down on mortgages, but you can extrapolate that some of this stuff, some of the rules of what we're saying, and some of the guidelines apply to that. So I'm a landlord, I sue Mr. Pichardo, and I win a judgment. Now, just as I win a judgment because he fails to answer, the court writes this judgment out saying Mr. Pichardo has to go. However, if that happened during the time of COVID, or it happened just before COVID began, and now you're going to execute the judgment, and it is the time of COVID, the courts are saying you can't do that right now. We're not allowing you to do that. You have to hold that judgment until another date, another time. As a matter of fact, you have to wait to May 1st of 2021 to even bring that up. And we're looking at that to make sure that timeline is not extended, because we don't know where we are with COVID. And all in all, the state, New York State and New York City is saying that we cannot have people out on the street. We cannot have people exposed to COVID or exposing others to COVID. And we can't take advantage of those that are less fortunate because they lost their job or they can't find employment because of the situation we're in. Ed, steer the wheel.
Yeah, I mean, what you're saying is correct. Just to let the audience know, the governor had put into place certain executive orders right after, the height of the COVID. We were talking about March, April, kind of putting a stop to all of these type of proceedings. The New York State legislature then, at the end of last year in December, I believe it was maybe even December 28th, they went ahead and they passed the COVID-19 Emergency Eviction and Foreclosure Prevention Act of 2020, which kind of put into law, as an emergency measure, by the way, what the governor had put in as an executive order, kind of staying these eviction proceedings. And Royce is absolutely right. If you're talking about some sort of persistent and unreasonable behavior that infringes upon the enjoyment of someone else's residence, those can still, go forward, and, that landlord can go ahead and file a petition and get some sort of emergency proceeding before the court to address that situation. But outside of that, because just let's keep in mind, we have non-payment proceedings, and what we have what's also called holdover proceedings, where the landlord has decided, well, you know what, you've been paying, but I don't want to renew the lease. I don't want to give you another lease. And even those are stopped. And what's happening at that point is that you're on a month to month. The big thing here that's really important to understand is that these stays do not allow you to stop paying your rent. You got to pay your rent, because what ends up happening is even after these stays expire, right now, this one expires May 1st, 2021. May 1st, 2021
That rent is
comes.
due. That money is
And we're talking about all of that rent, all of those months of
in
rent are due.
arrears, the whole thing.
Now,
So Ed, so I think there's a term, we use the term in abatement, right? In abatement, right?
yeah.
So what we're saying is that whatever monies you do have that you can apply to rent, after you take care of everything that you need to take care of, and I don't mean cell phone, I mean essentials like food, right? You know what I mean? You need to put that money on hold, put it away, have it in abeyance, hold it, freeze it. Because when the argument and the day comes that the landlord goes to landlord and tenant court and says, Mr. Pacheco hasn't paid since August, Mr. Pacheco can say, look, I haven't paid since August because of COVID, and I had these other things that I needed to fulfill. However, for every $2 I spent, I put $1 away. So I'm in arrears. I don't have full rent, but I'm very close to doing that. It's almost like we talked about with employment. You have to mitigate your circumstances. You have to limit your exposure. And no one's going to do that for you. You have to do that for yourself. So you have to put some of that money aside, even if, here's the slick one, right? Something's wrong with my pipes. My pipes are not working. I still got a leaky faucet. My toilet's not working. There's paint chips. You're supposed to redo my bathroom. Even with all those things that are traditional landlord-tenant issues, you still, if you stop payment, you need to have that money put aside, because the court can say, okay, these things have to be fixed, COVID or non-COVID times. You give us the money, we hold the money. The money's held in escrow. And if you ain't got the money, then what kind of 3-card Monte you playing over here? You understand what I'm saying? What you doing?
Yeah. No, exactly, because you have some landlord-tenant proceedings where the landlord is trying to, get you out of the apartment by not renewing the lease, even though they may have a legal obligation to, because it's a rent-controlled apartment. And in that, instance, there's a proceeding. You would place the rent in escrow while the proceeding is moving forward. Or if you are alleging a breach of the lease by the landlord in terms of habitability, or a failure to repair, once again, the remedy is for the rent to be held in escrow, not just complete non-payment. But in those instances where, because last week we were talking about jobs, employment, now we're talking about residential and evictions. There's a connection here. The connection here is hardship. You've lost your job because of the COVID-19. You can't earn enough money to pay the rent. What do? Well, I just want to state this for the audience. You may have heard about a national moratorium, right? National. The Centers for Disease Control, based on the COVID-19 epidemic, gave, that was used to then allow the president to issue a moratorium. Now, that's not a complete moratorium. What it is allows you to fill out a form, which is what on the screen, a declaration, which is interesting. It says declaration under penalty of perjury. Now, I would say, let me just say this, that is a very pessimistic label for this document, I must say. And I think it came out of this conservative mindset that people are going to lie on this form in order to get some sort of relief from paying their rent, when in fact you have a lot of people that are in economic financial hardship that can't just pay. At the same time, people do need to understand, and that's fine, that, listen, this is a government form. You can't lie on there. You can't say that you're experiencing some sort of hardship when you really aren't. And once you sign that, if later on, it's discovered that you lied on this form, you could be held to account. So you have to be very careful with that. Now, that's national. That's national right there. What's happened is states like New York, in New York, hey, listen, it's more progressive than other states. They issued their own, the New York courts have issued their own declaration form that tenants who are undergoing financial hardship are to file in court if facing eviction, letting the court know that they are experiencing financial hardship. I don't know if you can put that up on the screen because, of course, I would imagine that our audience is a New York audience. And that can be found on the New York courts website. If you go and you tap in and you Google New York courts, tenant, declaration of hardship form, COVID, you'll be able to find it quite easily. And I believe it's also in different languages. It's in Spanish. It's in I think even Bangladeshi. It's in different languages depending on the tenant, which is wonderful because not everybody speaks English, of course. Even though our legal system here is basically English based, but that's supposed to be a form that you fill out and you file in court to also bring a halt to these proceedings and also to get some time to maybe catch up on that rent. There's also, I believe, a mandate by the chief judge that for newer eviction proceedings that the landlord file an affidavit stating that the tenant was provided with this form. You talked about default proceedings earlier, Royce. You should, anytime that you get served with eviction papers, one of the most basic things you should do is show up on the date of that hearing in lieu of filing at least a written response, because that's what the lawyer most of the time would do. I mean, some lay people are more educated or gifted than others in terms of being able to handle that part of the process themselves, but you should always respond, or at the very least show up, let the judge know, hey, listen, I got these papers, I'm here. I'd like some time to find an attorney and or otherwise respond. And I can think of very few scenarios where you wouldn't get that ability to respond or at least time to get an attorney and time to file a response. In the time of COVID, that appearance would be made, of course, more than likely by way of video or Zoom. You call up your local court and find out, well, what are the procedures for that court in terms of making an appearance either by phone or by video in lieu of appearing in person. You also have a bar on, you mentioned the default judgments. Also, you have a stay on the execution of warrants, because if a landlord is able to be successful in terms of getting you evicted, the legal process is that the court then allows for the issuance of a warrant. That's when the sheriff part comes in and coming to the residence and putting the sticker on the door and the removal of furniture. But even if the landlord was able to get a previous warrant of eviction, even those are also stayed pending a status conference before the judge.
I would imagine in that same grouping of the sheriff and the warrants, you're not allowed to do what we call lockouts.
Yeah.
Landlords are not allowed to just change the locks.
No.
That, you know what, you didn't pay your rent, so we're going to change the locks, and therefore you can't get in. I just want to mention one other thing in reference to you had said and stated that the CDC form, which speaks to hardship, it started off with the penalty of perjury, and that was a pessimistic way of dealing with a form that is really useful or will be useful and should be used during this time. I agree with you. It is somewhat pessimistic, but I also say to you that it is very realistic, because people need to know that they're signing this document and they get caught, there's going to be a problem. And I want to emphasize that it's not always the person that's living in New York City housing or New Jersey public housing or someone that don't have a pot to piss in. It is those that have plenty of pots to piss in that figure they're going to get over, and they're going to use this time to not pay their $1 million rent that they have, because they're leveraged out. They got their vacation home, they got the retirement home, and then they got the apartment on Fifth Avenue, which is a condo or what have you. And, association fees have to be paid. And, you may not call it rent, but something has to be paid, right? Capital improvement has to be paid, right? And so therefore, they'll use something like this to get over. Just like when we think about public assistance, through media. Media has shed the light that, public assistance is another word of saying color folks, when we know it's not, right? We know that there's plenty other folks that are on public assistance that has nothing to do with being African American or the African diaspora. So when I look at this form and, putting a cultural spin to it, it doesn't have our name stamped on it. And believe me, those that are abusing it don't always look like us, because those who know the system will play the system. This show is designed to help you navigate and understand the system. And usually we're behind the 8 ball in even trying to do that. So we don't even have time to play loosey-goosey when it comes down to rules and regulations, versus someone that is versed in this, have lawyers and attorneys, have the academic wherewithal to understand what's going on, and then use a rule like our president, whether it's the tax code or something else, to their benefit, and then say, not shame on me, shame on you for having the rule. So
no. I mean, listen. My main thing was I put that. I compare that to the treatment of the loans that went to businesses, right?
That's right.
Which later on it was discovered that a number of businesses had committed fraud in terms of whatever affidavits or documentation that they had to provide concerning the need for the loan, no employees to pay, things like that. I didn't see this sort of pessimistic declaration at the beginning of those loans. It was taken for granted that if you're filling this out because you need the loan, then what you're saying, must be true. I'm sure on the form at the end it said, under penalty of perjury, but then to start it out that way kind of reminds me of the thought process, of the welfare queen and the demonization of poor people in America. I'm very much tired of that. How people assume that people are poor because they want to be, or they're undergoing hardship because they want to.
But that's why Ed, I brought it up, because I think part of our job is to, or at least my mission is to change the narrative, right? Yeah. This form is created. Don't think this form was created because it's created for me. Shoot, the people that created this form don't always have my best interest.
Exactly.
Hand, right? The trickle down effect don't always trickle down, right? So who was this form created for? Was it created for the people that live in St. Mary's Project? I scratch my head. I say do not. Is it people that live in Fort Lauderdale or somewhere else, that lives in a condo somewhere in New York City? Maybe so, because the power players put the pen to the paper to create a situation that maybe we could take advantage of, or maybe it's put out there for the greater good, but there's always a carve out that I can use it too.
I mean, I was listening to a very interesting discussion by the woman who heads, I believe, Color of Change. And she was talking about how many of these policies that are looked upon as benefiting people of color actually benefit poor whites in a much more profound way. But yet you have this narrative that affects the discussion, and these poor whites are voting in large numbers for these conservative Republicans who are fighting any measures towards financial relief under the theory that it's not going to help them, when in fact it is. I mean, the majority of people in this country that benefit from public assistance and Medicaid are overwhelmingly white, or are white. There's no question about it in terms of the population, right? And then you know, you got this idea of, you know, well, who's not being able to pay their rent? Who doesn't have it? I mean, come on, give me a break. And I was reading an article about how the CDC moratorium in some of the more conservative states, you know, judges are like not even following the precepts of the declaration form in those states that aren't New York, and purely the only relief is that CDC form. Some of the judges are like asking all these questions, and it's just, you know, instead of just taking the form and saying, okay, if you sign this under penalty of perjury, fine, I'm going to take that into the record. I'm not going to question you about it, unless, of course, the landlord of the opposing party is able to show that, listen, you have reason to question what's on this form. It's kind of like this mindset that if you're asking for this help or this relief, that you're probably, you know, not telling the truth, and let's dissect and question you about it. So
once again, it's all about who looks like who, right? People in power, people not in power. You know, the look in the mirror factor, the Michael Jackson, you know, factor, you look in the mirror type deal. But one of the things that we really need to emphasize here is, despite what you have said as far as the hardship is concerned, there's still always a carve out that deals with those that are a nuisance to the property. Don't think that you could be a nuisance tenant and still draft this hardship and think that you want to be around. You know, it's not going to happen. And when we talk about creating hazardous conditions to other tenants, we really have to look at that, because we might say that and hear that term and go to the, what I call, there's black and white, but what about the gray, right? Go right to the black or go right to the white and forget about the gray. And what do I mean by the gray? When you talk about hazardous conditions, are you talking about somebody that smokes a lot now, who doesn't go outside and smoke in front of the building because they got to have their mask on, they got to take their mask off, decide that now they want to smoke inside their apartment, whatever they're smoking, which interferes with the next person, right? And then that next person can't use their quiet and enjoyment. And it might create a hazard, because we know secondary cancer happens. It's a real thing. I mean, we have to really dot the I's and cross the T's on this, right? This is not just some, you know, wave a brush 1, 2, 3 and be done with it. This is real issues, real problems, things that have subtleties that a landlord, if they're smart, can bring an action, and bring an action without having a red face. Now, for me, it's very hard for me to get a red face. Ed, you a little easier. Some other folks a little easier than that. But they could bring that argument to the table and say, Judge, I'm serious. What are we talking about? You want to talk about secondhand smoke? You want to talk about these things? Here it is. And so let's don't be so smart, right? Let's don't be the Pete Carroll and don't run the ball when you're on the 1 yard line. Oh, here we go, right? Here we go again, right? Right? You try to pass the ball, right? But don't be so smart, all right?
That's why we may get Russell Wilson with the Jets. You heard about that.
Here we go with it. Eddie Russell's a good Russell. I just want to let you know that, brother. Eddie Russell's a good Russell. So take what you can get. And, you know, it takes one to know one. You know what I mean? You know?
What a coincidence.
What a coincidence.
All right. We are not going to talk about the game now. We're going to get back to this, because I want to circle back to what you stated. I believe, Senor Pacheco, you were talking about the fact that if you don't pay, or you're in a situation where you even put something in, you still are responsible for the arrears. So it's not like you file a hardship, whether it's a federal, whether it's New York State, whether it's another state, and that just wipes away all of your rent money. Like, it's just a whoop, it's gone because you filed for hardship. I think we need to underscore that as well, because some people might feel, well, if I apply for this and I get the abatement, or I get something in writing, that I'm in the clear. And I want us to just circle back on that, so that we can culturally make sure that everybody is aware that you're still responsible, even if.
Yeah. Now, I will say this. Okay, you are responsible. Now, what I would advise tenants to do is I would advise the tenants to request a record of payments from the landlord. Sometimes those record of payments, those payment ledgers, will yield some very interesting information, because if you haven't been paying your rent on time, or if you've been paying it on time and the landlord is somehow claiming that you're paying late and is adding interest charges, you might be surprised at what the calculations of the arrears are, you know, in terms of late fees and the like. So that's something to look at. Also, one of the things that you can contest during one of these types of proceedings is, and lawyers will often do this, they'll raise a defense called lashes, LACHES, that the arrears that the landlord is claiming are very old, that they didn't ask for these arrears previously, and now all of a sudden they're asking for them now, and that it's unfair to you because if you would have gotten notice, you would have had a chance to either contest those arrears or make sure to have paid them. So, you know, that's a defense that comes up many times in these proceedings. Make sure that you keep all of your rent receipts. A lot of times folks will go maybe to an office and pay in person, always ask for a receipt. Or if you are doing checks or money orders, make sure that you put the month and the year that you want that rent payment to be applied to, because the landlord may say, hey, listen, she been owing or he been owing that money from last year, so I applied it to last year's rent, but you see, he or she still owes, you know, this month, this year's, or whatever, these last couple of months. So you know, you have to be careful with that. You know, keep those receipts, especially if you're in a situation where you're dealing with a landlord in many cases who just bought the building brand new, doesn't like all these rent control tenants, wants to go, you know, high luxury market rate. You know, you got all these people living here from 30 years ago paying this, you know, low rent. I'm trying to collect the big rent. So they start trying to find all types of ways to, you know, get you out of there. You know, like you mentioned earlier, Royce, the whole idea of, well, I don't got, you know, they haven't repaired this or that, so I'm going to automatically take it out the rent. You know, you can't do those things. If you want to deal with those issues, you know, you file a complaint. You file and say, you know, there's been a breach in the lease and I want this repaired, and try to deal with that the legal way. You know, that other way that you're talking about in terms of I'm taking this whole issue into my own hands is not gonna work out for you in the end. I remember, you know, a dear brother that I knew many years ago decided that he was gonna take all these repairs he did to this apartment he didn't own out of the rent and stop paying rent. Eventually, you know, went to court with that, and the judge looking at him like, "What you talking about, Willis?" You know, and he ended up.
You know, see, here goes something there. See now, you throw a little something in there. You throw a little. What you talking about, Willis? You know, Dr. Grant give you all type of smiles and everything. Now I throw something in there, and I'm getting the screw. You know, like, you know, the mean mug. You know what I'm saying?
Oh,
it was well played. It was well played. Avocado. You got in where you fit in. But to your point, Ed, and Jesse just put this up on the screen. He must have been reading my mind. Is that it really is about documentation, right?
Absolutely.
It's about putting down and memorializing and writing down who you spoke to. For some odd reason, culturally, we have an issue with asking, and your name is, or what is your name, before we get to the guts of what the issue is. So we have a name, writing down the date and time that you spoke to somebody. If you served somebody and gave documents to somebody, then note that as well, that you gave documents to somebody and you served it to somebody. Take the appropriate steps to be legal and do everything by the book as much as possible. There is no time for shortcuts when you're talking about your place of living. And you need to know that. Make a copy of everything that you gave to everyone. Keep it. There's a reason why you need that documentation. Somebody may ask for it at some point in the future. Dr. Grant?
Yep. You know, we have a few more minutes left on the show, and I think this is important to just make sure we're aware of with rent, but also let's just touch on what about those with mortgage situations where their issue is because of COVID implications and all the other challenges that have happened, they're behind on their mortgage. What say you about that before we wrap up? And hey, Sam, hey, Jesse, hey, Mecca, thank you all for tuning in. Appreciate seeing you here. Hey, Avis. All right.
Well, in reference to that, you know that is a one-on-one relationship between you and the private entity, right?
Mm-hmm.
And so the private entity, whether it's Chase or TD Bank or HS or you name it, Citi, they own those documents. Or if you use some ally bank, and so that is a conversation that needs to be had up front. No bank wants to have property sold at a short sale. That means you're selling it for less than the value that it really is, or have any type of foreclosure. So that is a conversation that is had. That is a conversation that you see something like that CDC form is floating around somewhere for the use of somebody who has a home to kind of create a scenario where they receive some type of relief. Believe me, it is out there. You just have to make sure that you use what you have. Instead of taking a cell phone and taking a selfie, go into the browser and type in something, see what comes up, and then take it from there. And then if all else fails, and you see this even on the New York websites, whether it's New York courts, .gov or NYC evictions, you name it, you see it, where it says call your local bar association. They're telling you, call the local bar association, call the attorneys that are associated in your geographical location. There is a hotline, there is a helpline, there is somebody waiting there with bated breath who's been sitting by that phone all day looking for somebody to call so they can direct them to the right person or the right people or the right area of law. Use it.
Yeah, my understanding is that there's a hold on those proceedings are in abeyance as well. But Royce is absolutely right. Anyone in that situation should look to contact that bank and try to see if they could get some sort of forbearance, on the payment of the mortgage while this pandemic is taking place. Trying to see if they can get some sort of relief on some of the interest payments. But no matter what, make sure you respond or attend to any legal proceedings or papers that you are otherwise served with. I mean, before a residential foreclosure, you're gonna get the opportunity to show up in court, meet with a mediator, and try to see if there's a way to resolve that matter prior to the ultimate grant. Of course, while the legal proceedings are taking place, it's extremely damaging to you. Once that lis pendens gets filed and it's attached to the property, you want to try to get that removed, if anything. But yeah, I believe there's also a hold on those proceedings pursuant to here in New York State, pursuant to the act that was passed by the legislature at the end of this past year, 2020. I didn't delve too deeply as to the enhanced protections with respect to those residential foreclosures, other than a stay of those proceedings for now, which, once again, if you're having a hard time with that mortgage, it doesn't mean that you can, if you don't have the money, fine. But if you have the money, you have to pay. It's not going to be any stay of the pay. The only thing that's going to be stayed is the proceedings, not the payments. They're going to claim the whatever amounts of monthly amounts of mortgage that you're in arrears for and that you owe. They're going to be able to request that and the payment of that, and you're ultimately going to be responsible, unless, of course, you reach some sort of deal with the bank where there's some refinance and they forgive, some part of that principal or loan and start you anew. That's some of the stuff you saw during the Obama administration, as a follow to the housing crisis, and a lot of people in danger of losing their homes, which inordinately impacted the Black community, heavily. in terms of
one of the things, it's not all gray. So I don't want to paint the picture that it's all gray, right? Because in landlord-tenant court, the landlord wants his money, right? And sometimes it's best to know the person that you're dealing with than the unknown. So you might see yourself in a situation where a stipulation is drafted, where both parties agree that you're going to pay a little bit of the arrears every month. So instead of your rent being $350, now it's $400. The other $50 go to the arrears, and that's back rent that is owed. And that happens over a period of time until you get all caught up. Because anybody that owns property, if they have someone that's decent, treating the property right, treating the apartment right, has been with them and has been consistent, but for this hiccup here, then that's a relationship that you want to maintain, and you try to have it so you can maintain it. You know what I mean? You want it to live on.
The only thing I would say, though, before you sign any stipulation, make sure you understand what you're getting into, because a stipulation most of the time will require you to give up your right to then take that case to trial, right? Because if you are getting into this agreement where you pay into these arrears and later on you stop paying again, and the landlord says, okay, we back in court again because you breached our agreement, you breached our stipulation, you stop paying, now I want my warrant for eviction. You can't go and say, time out, I want a trial now to contest those arrears and whether I should be evicted or not and all of that. So, just be very careful that whatever arrangement you enter into, you don't enter into it too quickly. Enter into it realistically, like, okay, I can pay that. Don't agree to some amount that you can't pay just so you could hurry up and get out of court and say, oh my gosh, I dodged the bullet. But and that bullet is going to be coming back to you a month or 2 months from now because you can't pay that amount, And if you truly feel that those arrears are not accurately stated and unfair, man, take that joint to trial and fight it. You know what I mean? Because and more than likely you may also extract some concessions from that landlord, because a lot of these housing judges, they really don't, the issues are so narrow. They don't necessarily want to have a hearing or a trial on this stuff. They want to try to get the parties to agree.
So we have one question and we have a couple minutes left. And that was Jesse asking, were the banks mandated to forgive due to COVID-19?
That one I'm not sure.
I've never heard the word mandated.
Yeah.
Right? That means that the government says you have to do it. And the reason why you don't hear words like mandated is because you're talking about a private institution. Although it might be federally insured, you're talking about a private institution. So the words mandated takes a whole new meaning. It might be constructively mandated, right, that you do something in reference to COVID. But the word forgive is something that the government won't ever say either when it comes down to private institutions, because they're not in a position to say that Royce Russell's bank has to forgive, Jesse Taylor because he owes money. No, this is my bank, my rules. He owes the money. I understand what you're saying. I'll take it under advisement, but these are the rules here. One of the things I wanted to say in regards to what Ed said, and I agree with you real quickly, is that you want to make sure you have the right attorney or have a knowledgeable attorney, because you don't want to protect yourself out of a possible situation that's beneficial. So that means if the landlord comes to you and says, you know what, you get out tomorrow, forget all the arrears, everything is done and over with, you might want to consider that rather than having the pain happen over a long period of time. My father used to tell me, you want a beating or you want punishment? I'll take the beating right now, because that lasts a couple of minutes. I might be a little sore, whatever the situation is, God rest his soul, but then I can go outside. That punishment is Monday, it's Tuesday, it's Wednesday, it's Thursday, it's Friday, it's 5 o'clock, it's 6 o'clock, it's 7 o'clock, and everybody outside is having fun. So sometimes the beat down.
Oh no, I used to hope my mom would forget about what I did earlier.
No, they didn't forget.
That's a whole nother show for a whole other day. But just as we started on a high note of remembering an icon in our Latin community, I want to end on a high note with a namesake who was killing the game.
Oh, my girl Stacy, she was rocking it.
Yeah.
Take care, Representative, even though she spells it with a Y, you know, there's no Y in my name, but Representative Stacy Plaskett, my West Indian sister, representing so well in the trial. You know, I just have to shout her out for her fashion, which come to find out, her girlfriend, I think two of them got together and say, look, you don't like to dress up, but you're going to be dressed for this occasion. And she was able to garner a lot of media attention just off of her fashion during the trial. We know it didn't turn out the way most would have liked, but she was represented. And you know, I just love that blue. So I just had to shout out my namesake before we shut down today's show, where the cultural meets the legal, because hello, her name is Stacy. One, she's a black woman. I mean, two, she's a black woman. And she was very articulate and passionate about litigating the case that turned out differently. I don't think anyone was surprised. We knew what was coming.
Her roots are from the Bronx and the Bronx DA's office. And I remember when she first came through the front door. You know what I mean? I ain't gonna take credit, but I'm just saying I remember. You know what I mean? I remember. You know what I mean? I remember. A lot of people taking credit for me, but they just remember. You know, hey, you got a lot of credit, people. Go up 125th Street.
Hey, I believe I believe I met that sis at an event that Hakeem was having in Washington D.C.
She's good people. She's good people.
It's really beautiful. I just want to say real quick in terms of that proceeding, man. Michael Che said it best on Saturday Night Live. It was a strange proceeding where the jury were made up of the victims and they eventually voted to acquit. It's just strange, strange.
Look, and I need to say it. I need to say it so we really understand it. The jury was made up of the victims, so that means the Congress people were the ones that were victimized by quote unquote Trump. And those victims, you would want the person that victimized you, you want that person to go to jail. No, they decided to acquit. So they let the defendant go. Like, come on, man. For real?
It didn't hurt that bad.
Mm-hmm.
Oh boy, it's a sad day. But you know, for politics and other reasons that they made that decision, it will live as a stain on their record in history. You know, our children's children will be reading about what happened in 2021. So
this date will live in infamy.
Okay,
FDR.
It sure will. Well, this has been another colorful show, Speaking Legally, where the legal meets the cultural. We only do it our way with our two legal experts that we have, Royce Russell Esquire, Edward Pichardo Esquire. We appreciate you being here. We look forward to seeing you next week because we know we're always at the curve, right at the precipice of what's happening in the news. We bring it to you, break it down so you know you can be armed with right information and not just listen to what I call the sidewalk attorneys. You have two licensed attorneys who understand what it is that they're doing, their passion for our community, and making sure that we have the right information to make good choices and good decisions. So stay safe, stay well. Coronavirus hasn't gone anywhere. COVID-19 is real. Wash your hands. And if you are taking the vaccination, be careful with your care in between. A lot of people, you're welcome, Jesse. A lot of people out here are still taking this very casually. So let's not be casual. And let's do what we need to do. Gentlemen, final words before we close off.
Well, I can tell you next week I'm going to bring my dictionary because we got the word forbearance. We had the word precipice. We had the word, I mean, like I'm hearing all these words come out of, hey, I'm like, well, wait a minute, you know, but okay, I see. We're not going to play Scrabble with any of you because y'all know how to play because those words are too big to put on the board to even spell, but that's okay. Everybody, we see you next week.
All right. Take care. Peace.